Watching the application brought by Dr Nandiphia Magudumana, she wants to be released on bail. Of course, as we now know, played a big role in the escape, we understand, or we're told, of Thabo Bester. The magistrate in the case ruling in Mangaung just a moment ago that she will make her decision, she will announce her decision on the 11th. That's next Monday. Quite tense legal argument today from Magudumana's advocate. Nthabiseng Dubazana is an attorney at Dubazana Attorneys. Nthabiseng, good afternoon to you. So we have a person applying for bail, has already skipped the country once, and also has no fixed address. I would imagine her lawyer has to bring a pretty overpowering argument under those circumstances.
Definitely so, Stephen. In terms of Schedule 5, which is the schedule in which this bail application was heard, she would have to show the court that it's within the interest of justice that she's released out on bail. So the onus solely and squarely relies on her. But when you listen in the manner in which the defense attorneys have addressed in terms of the closing argument, they seem to want to change the onus to be that of the state, which does not make any sense whatsoever. And then over and above that, they also want to challenge the issue of the schedule itself. And now my problem with that aspect is that if you had an issue with the schedule, it should have been done before you read out the affidavit under Schedule 5 and let that be determined prior to you guys actually doing or dealing with the matter itself. So at this stage, I think the defense's argument is not very well founded in law and in terms of how criminal procedure is supposed to run. So it's really very interesting to see how the judgment comes out.
There's another issue which I must say I found this very interesting. Her argument, as I understand it, is that she must be released because she's the primary caregiver for her two young children. But she hasn't, as we've been told by the state, contacted them all this time that she's been in jail since she returned from Tanzania, or her husband, I presume, the father of her children. Does that matter? I mean, is the magistrate going to look and say, well, you're saying you want to do ABC, but in fact, you've shown no interest. You haven't contacted them. You've shown no interest in doing ABC.
The defense attorneys, I think they were raising that as a mitigating factor for the court to consider it when they want to release Nandiphia out on bail. But it may just, like you just said, act as an aggravating factor wherein she hasn't made any contact with the minor children. And the fact that she's claiming that she's the primary caregiver of the children, I think is a little misleading because she was, and if I'm not mistaken, still is married to the father of the children. And therefore, in terms of Section 28 of the Children's Act, Section 25 of the Children's Act, and Section 40 of the Children's Act, they both share equal rights and responsibilities towards the kids. So there was no primary caregiver. Usually a primary caregiver would come in a situation where the parents have split either by divorce or the romantic relationship has died, and therefore the kids are now residing with this one parent and then the other one has access. So that has not been proven. There's no parenting plan that has been brought to the court to show that she is indeed the primary caregiver.
There's another issue where there is a sort of trail, let me put it more carefully than that. The state claims that there's a pattern of dishonesty. I mean, there's a car that wasn't, a rental car that wasn't returned. There's all sorts of things, many charges of fraud. If someone is accused of having a pattern of dishonesty, when they now bring evidence as part of a bail application, is the judge allowed to sort of look at that pattern of dishonesty, or must they take the evidence given by the applicant at face value, even though there's strong claims with evidence that they lie?
The presiding officer has to scrutinize the evidence before it and weigh it against the interests of justice and the interests of the accused person or the applicant in this case. So they can't ignore it and just take the statement of the applicant on face value. That's why there's always an opposing affidavit from the state, like we've seen in this particular matter. Then the court just has to look at all the aspects surrounding this case. And the beauty of bail application is that it's not on beyond reasonable doubt. It's on a balance of probabilities. So there's no real onus on the state to prove that indeed this accused person is going to be found guilty of this charge, is going to be, and all of these other things that she's facing in terms of the charges against her. The onus really solely relies on her to prove to the court that she is a suitable candidate to be released out on bail.
There's so many aspects to all of this. If she loses this case, can she then appeal the decision not to grant her bail if that's what happens?
Of course, she can do that. However, it may be a little bit premature because the trial really hasn't started. But we will see. I think in terms of the fact that the matter is still under investigations, she may have leeway to appeal the decision of the bail application to the High Court and let them decide based on the information that was alluded in this particular hearing, if they'll be granted bail. And if she does get granted bail, then she can continue with the main course, but not main course, I beg your pardon, main case, and then take it from there. So she will have leeway to do that, to appeal the decision.
Normally, what you would do, I suppose, one option for a magistrate or a presiding officer in a case like this would be to reduce the flight risk. You would then make bail very high. You'd make bail expensive. In other words, you'd try and really guarantee that the person comes back. The problem in the case of Magudumana, and again, let me try and choose my words carefully and get them legally correct, is back to this trail of dishonesty, that she may well be the beneficiary of ill-gotten gains. In other words, she could put up a lot of money, even fixed property for bail, but it's not hers.
That is definitely the case. I think that is why the state, when the state was reading out the affidavit, they were focusing so much on the many businesses that she's the director of and the amount of monies of fraud and the cases that are yet to come. Remember, I think they were reading out about 4 or 5 different cases that pertain to about millions of rands, wherein she was a participant in all of those cases. She's yet to be charged of those cases, but it shows that there's a pattern of dishonesty there, and also the fact that there is a second passport that is alluded to, and that passport is not within the hands of the state. It therefore gives the state an uneasiness in whether or not the accused being released out on bail, they would actually come back, because they can pay money. The passports may be taken in, but we have seen that she had used a previous passport that belonged to somebody else to cross the border in the first place. So we can see that there's nothing that may prevent her from leaving the country in any event.
Nthabiseng, from what you say, I don't want to put words in your mouth, but it seems to me you might be surprised if she is granted bail. Would that be right?
100%. I'll be very, very surprised, because the way in which her defense team is arguing versus what her affidavit said, that worlds apart. The argument is not giving strength to the affidavit, which is what they are asking the court to really consider. Argument is one thing. What you've put under oath is what is really going to be considered. So it will be very strange if she does get bail indeed.
Nthabiseng Dubazana from Dubazana Attorneys, really appreciate the time. Thank you.